fell in right place, and the cherry on the cake was that we succeeded in that matter. So yeah, across trial courts, everything. So first suggestion would be that please fill those. My point is, please have the vacancies filled, even if there are some judges who may not be as good, or if they make errors. Allegations of corruption have cropped up against, say, high court judges, and certain orders. But while dismissing the bail, he did make that observation orally, and my client was standing there, that your bail would get dismissed from the High Court also, but make sure that you retain Mr. Suri, because the way he has argued before me, there are chances that you may get bail from the Supreme Court. That was, I think, time has come that even judges of high courts, and a majority, not a one or two or three judges, because then it seems that it is like a stigma, or the judge being transferred perceives it as if it's a punishment. The government would be more interested to stretch the matter in courts, to litigate over it.
Okay, talking about that, you are a AOR right now, like that is advocate on record. So, and you have been into courts, Supreme Courts as well, and you've been also practicing in Mumbai. So, you have seen a good dynamic of the Indian law system and Indian like judiciary in general. So, if you could make few changes today, like sitting up here, and you could suggest some changes, what it would be?
See, now since you talked about me being an AOR, let me also tell you that Mahada matter, the one which we had just discussed, that was my first matter as an advocate on record. So I did write that exam quite late in the profession, for reasons which, if uh, certain questions, if you ask, I'll definitely let you know about them later in the podcast. But so that is also one of the reasons why that matter holds an important place. That was my first matter as an advocate on record, where I had filed my wakalatnama in that matter before the Supreme Court. I argued many matters as arguing counsel before the Supreme Court before that, but being an advocate on record, that was the first matter. And in the first matter, having these legends appearing alongside you, and you getting to argue that matter because the senior counsel who was engaged by the client didn't turn up. So everything fell in right place, and the cherry on the cake was that we succeeded in that matter. So yeah, that's the AOR aspect. The second aspect of being an AOR, which I think is slightly different. Firstly, I feel whether you are an AOR or you are not an AOR, what matters in the litigation is whether you are able to score clients or not. So I know many people who are not AORs or who are not advocate on record, but still they have a decent practice because they are able to score more clients than, say, another advocate who may be an advocate on record. So essentially, in litigation, after a certain point, that is when you go independent or you start an independent practice, what matters is whether you are able to get clients or score clients from various fields or not, and what is the quality of those clients which come to you. That's one thing. So whether you are an AOR or a non-AOR doesn't matter at all. The reason why certain people write that exam is to have that sort of control over the matter, that limited procedural control over the matter. That, say, for example, when I was a non-AOR, I used to draft the complete SLP. I used to send it to my AOR, and then I just used to call him, say, two or three times, that whether it's fired or not, what defects are there. So all those things are avoided if you yourself become an AOR, because then your office handles all the filing, removal of defects, interacts with the registry. If there is anything which needs to be complied with, you do that. And the last aspect, or the last thing which I think being an AOR gives you an advantage over others is, which may be a small advantage, is that, say, for example, if there is an urgent matter, if there is a matter which has some urgency in it, then you directly can draft it, file it, and do it everything as per your own convenience. Whereas if you are a non-AOR, and if some urgent client or a client requiring some urgent relief or something comes up, then you need to look towards an AOR to do something at your convenience, which sometimes may not match. Sometimes that AOR or that AOR office may not be available at that point in time. So therefore, that's the only limited advantage of being an AOR, that gives you filing control over the matter or the control with respect to the interaction with the registry. But beyond that, I don't think being an AOR or a non-AOR is of any consequence. If you're not able to get a client, then you're as good as a non-AOR who does not have a client. So basically, just being an AOR by itself is nothing. It's an added advantage, but you need to have some underlying assets. You need to have some underlying things below your bed or under your bed that would add advantage of you being an AOR. But being an AOR by itself is nothing.
So, sir, if you could suggest, let's say, because you have been practicing law and you actually go to court, so you have seen a lot of people, lot of cases throughout your journey. So, if you could make changes in the Indian law system, or if you could tell that, okay, this thing might change in a good way, so what are the few things you would suggest?
See, first, I would have like four suggestions. First suggestion would be that at present there are enormous vacancies across all courts in India. So there is a concept called sanctioned strength of the judges and the actual judges which you have. And I don't have the exact figures, but in certain high courts, such as say Allahabad High Court, the vacancy is say almost 30-40%. The number of judges sanctioned is say X, and the actual judges which are working are 30%, 30 or 40% less than that particular number. So there are a lot of vacancies across all high courts, across trial courts, everything. So first suggestion would be that please fill those vacancies, and especially at a high court or a trial court level, you can afford to have some judges which may not be perfect in all aspects. They may make certain errors which even a very fine judge is bound to make. So therefore, because that's the argument which is given whenever the suggestion is made that please fill all the vacancies, that's the argument which comes from the other side, that we don't have that much of capable people, or we don't have a pool of people which who can take that mantle on themselves to adjudicate disputes in a impartial, neutral, and in a very integral manner. So that's the argument which is given back. But my point is, please have the vacancies filled, even if there are some judges who may not be as good, or if they make errors, those errors can always be corrected at a higher forum. If it's a trial court judge who may have made errors, those errors can be corrected by the High Court. If an error is committed by the High Court, that can be corrected by the Supreme Court. So that's not an argument to keep so many sanction strength vacancies lying vacant. So that's number one, that you should fill vacancies. Now, point number two, and this is specifically with respect to the High Court. Now, I don't know how the judiciary, because in India, it's the Supreme Court primarily, which is the custodian of the whole judiciary, because our judiciary is an independent, we have an independent judiciary. It's not as if government has control or say in terms of transfer or appointment. It does have, over a period of time, it does have some sort of consultative value, that whatever you say may be factored into, but the final decision making is with the Supreme Court and the High Courts. So the second suggestion which I would like to make is, because in recent times there have been instances where a lot of allegations of corruption have cropped up against, say, High Court judges, and certain orders have been passed by the Supreme Court which borderline suggest that the High Court, the Honorable High Court judge, uh, should have decided a case in a particular manner, considering the facts of the case and the laws involved. but the judge chose to look the other way, which means that something was wrong or some other consideration besides the legal consideration could have been there. Even though the Supreme Court has not said it in such clear terms, but there have been various orders recently passed by the Supreme Court, especially against one particular high court, which happens to be the largest high court in the country. So, be that as it may, I would suggest that transfer of high court judges is normally considered as something as if it's a punishment till now. But I think the time has come wherein transfers in higher judiciary should be looked as they are looked in, say, bureaucracy or other aspects of public discharging public functions. That if there is a particular secretary or a particular bureaucrat or a particular police officer, he doesn't stay in that particular location like throughout his life or till he retires. They keep transferring every 3 years, every 5 years, they get transferred. So I think time has come that even judges of high courts and a majority, not a one or two or three judges, because then it seems that it is like a stigma or the judge being transferred perceives it as if it's a punishment or if it's a stigma on his professional caliber or career, and that's why he or she is being transferred. That should end according to me, and there should be transfers on regular basis despite of no complaints and despite of the fact that even if a judge is working perfectly fine, after some time that judge should be transferred. Now the difficulty in transferring high court judges amongst other high courts is the language barrier. Let's say, for example, if a judge who's presiding in a in a high court in northern part of India may not be well conversant with the language of, say, South India or Tamil or Malayalam or Karnataka, Kannada. So there are ways to tackle this problem. Like I just off the cuff, I can think of that. Okay, you transfer such judges only to the northern belt of India or in the northern part of India, but something has to be figured out in that aspect because once a judge or high court judge is appointed, most of them are now comfortable with the fact that now we are going to stay in this particular high court till the time either we are elevated as Chief Justice or transferred as Chief Justice to some other High Court or we retire. So that is something which I feel needs to change. The second is the transfer of judges in the higher judiciary. Mind you, in the lower judiciary, transfers happen every 2 years, 3 years, from one district to the other court, from one city to the other city. So in the trial court, that happens every 3 years, 4 years, 5 years. It's only the higher judiciary, that is the high courts across the country, where the concept of transfer is not there, and the judges who are transferred, most of the time, it is perceived as being a punishment. The second is the transfer. The third thing is that there should be some time bound arguments, or Supreme Court has recently come up with a circular that in certain final hearing matters, the arguments put forth by the counsels should be time bound and they must beforehand submit an estimation of how much time they would take, and they are expected to stick to those timelines. So that's the third suggestion, that arguments should not go on endlessly for days and weeks, uh, whether it's any matter of any importance. The whole art of being a good lawyer, or the court craft of law, or the legal court craft, is how concise you can be, how precise you can be, and how well you can communicate your legal propositions in as less time as possible. So that's third, that lawyers should also be asked to check the length of their arguments or the time they consume in making their arguments. And the last, which I feel is, and which which is that the judges, especially at the high court level, should be more reluctant in granting adjournments, number one, and especially to the state, because or the government, because my experience has been that 9 out of 10 times, if the government council asks for an adjournment or an accommodation, it's quite happily granted to that particular government council. So the kind of leverage or the kind of latitude which government or instrumentalities of government enjoy in higher high courts or the higher courts should be curtailed, and they should be treated like any ordinary litigant. If something is to be filed within a stipulated period, and if that government department has not filed it, courts should come down extremely heavily on such matters. And I must say that the Supreme Court has, the recent trend is that the Supreme Court does, and there are many judges who don't grant that sort of latitude to instrumentalities of the state in terms of not following timelines or filing SLPs after considerable delay. Supreme Court has come down quite heavily on that, but the higher courts need to do better in terms of not giving the instrumentalities of state the kind of leverage or latitude which they give.
So apart from this law as a like as a topic, you have also been so much involved in the global diplomacy. So you have been also invited by the minister of the METI that was in Tokyo. So how was that experience, and how does Japanese government or what does Japanese government would look up from an Indian lawyer or an Indian person in general?
So see, basically that was also a function of me being present at the right place at the right time that I got that invitation, which was indeed a privilege. But and more and like many details I can share on this podcast. But what I can tell you is how I got that, and why I was also quite keen to go there was that normally you would have seen that from 2014 onwards, and I'm not saying that didn't used to happen before, because anything which is to do with foreign policy, anything which is to do with foreign investment, it doesn't happen in 5, 10, or 15 years. It's a process which happens over decades. So, but be that as it may, after 2014, uh, we did see considerable Japanese investment coming to India, foreign investment coming to India, whether it was the government of Japan granting loans at lower interest rates, or whether it was private sector of Japan investing in the Indian private space. But there has been a surge in the Japanese investment in India. And therefore, when these investments come to India, or these companies or conglomerates come to India, they need people who know how to navigate the legal system. They need people who know how to navigate through the Indian system, Indian ecosystem. And that's what I brought to the table, that what are the laws where they may get stuck in terms of particular law or particular aspect of the law, which court, which senior counsel, say for example, if they got embroiled in a litigation, then how to go about that litigation, how to manage that litigation, how to strategize that litigation. So all those were the topics of discussion and concern, and there were a group of companies which then did interact with me at a professional level and sought my professional assistance once I was back to India from there.
Yeah. So talking about like when you have visited there, what is the biggest legal myth that you think is foreign government have about doing business in India? As you said, they come here to invest.
There are many things. First is that in India, and like I told you, that's why I said the fourth thing is a lot of latitude and leverage is granted to the government as a litigant in higher courts. So one thing which any foreign entity, not just Japanese, any foreign entity or any foreign entity which operates in developed world faces in India is that the litigations don't come to an end. And essentially, it's a very common phrase now, that process itself becomes the punishment. That's true for criminal law, but even in civil matters, even in disputes involving commercial matters, you find they being dragged quite a lot. And we need to understand that Delhi and Mumbai are not the only high courts in the country. There are other high courts also, and those high courts may not operate with the same efficiency and with the same pace as these two particular high courts, or for that matter, even Gujarat High Court is quite a vibrant high court to that sense. But there are various high courts where commercial matters are not understood as clearly or as pragmatically as they are understood by judges presiding in, say, Delhi High Court or Bombay High Court. So there are matters, just to give an example, arbitration is not some pre-litigation exercise that you first go to arbitration, then you get a finally you get an arbitral award from the arbitration panel or the arbitrators concerned, and then you start the litigation exercise. It's not like that. But there are many high courts in the country which day in and day out interfere very liberally and very jolly well with the with arbitral awards being passed. So companies or foreign investors in that sense, they feel that in other jurisdictions, arbitration is a parallel form is parallel to litigation. It's not a precursor to litigation in courts. So there are various high courts in India which treat as if arbitration is a pre-litigation adjudication or a precursor to litigation. So these are common issues which are faced by these entities. The other thing is the concept of mediation is not there. That most of the times, if any commercial matter is referred to mediation wherein government is involved, the government would be more interested to stretch the matter in courts, to litigate over it, rather than to arrive at a settlement or mediate with the private party and get over the whole dispute and get on with their things. So that concept of mediation is also not that. However, I must say that the concept of mediation has picked up in the recent past, but it's still not close to where like these foreign entities expect the the mediation or the lack of interference by the courts in arbitration matters. It's nowhere close to what they expect or what happens in developed jurisdiction. I'm not saying that we are not progressing, but all I'm requesting or all I'm suggesting is that it would be better if we progress faster enough.
Yeah. And along with that, sir, if you could put up some light on the Sonu case that you have also defended, so about that.
That which you may be talking about, that must be the
Yeah, yeah, you defended a judge in that.
judicial officer's case. So see, so that case, that was the first time that case is the first case which I ever appeared for a judicial officer. Now, who are judicial officers? Judicial officers are basically they are trial court judges. That is, they are judges who adjudicate matters in the district courts or in the district judiciary. So in Delhi, you have many bold judges, many judges who don't shy away from passing remarks or past strictures against the conduct of, and I'm not saying there are no board officers across India, I'm sure there must be many, but I don't practice anywhere else. And until quite recently, I never used to even go to the district courts in Delhi also. But it's only after COVID that I had started appearing in district courts for very selected matters, where the client would insist that he would want me to be present in that particular district court or before that court. So, but that's post COVID. So I didn't know this particular trial court judge in Sake, but I had argued a bail matter before him in Sake. And uh, when we met for his case, then he told me this thing, and then I remember that When I argued that bail matter before him, it was an enforcement directorate case, and I had argued that bail matter, and he did dismiss my client's bail in that particular case. But while dismissing the bail, he did make that observation orally, and my client was standing there, that your bail would get dismissed from the High Court also, but make sure that you retain Mr. Suri, because the way he has argued before me, there are chances that you may get bail from the Supreme Court. That was my level of argument and preparation before that particular judge in that ED matter. So, and somewhere it stayed with him. And that's when he got in trouble, because he had made some remarks or observations and passed certain directions to the Commissioner of Police Delhi and the Union Home Secretary to take certain sort of action against a particular station house officer in his jurisdiction with respect to the conduct or discharge of that functions by the police officer in a particular case in some investigation, which he didn't do as per the accepted standards of investigation. So that happens. That so police by and large does try to make sure that they follow all the legal aspects of investigation, and they try to do their job to the best of their ability. But there are aberrations everywhere, there are exceptions everywhere, and you cannot fault that even they are quite overburdened and they are quite short of the numbers which they should have. But be that as it may, there was a case which came before that particular trial court judge wherein the investigation was not conducted in a manner how it should have been conducted, number one, and the fact that certain forensic reports or certain prior crime involvement information reports were not updated as they should have been as per the prevailing circulars and notifications issued by the Commissioner of Police Delhi. So this particular trial court judge passed remarks, strictures, comments against a particular station house officer in his jurisdiction, and he asked the Commissioner of Police Delhi and Union Home Secretary to take some particular action with respect to that. That particular police officer, because it was quite severe and these are government jobs, so you tend to be very uncomfortable if such are not challenged or they are not removed from the record. That may cause problem to these government servants. So that police officer approached the High Court and sought deletion of these remarks and strictures, etc. So what the Honorable High Court of Delhi indeed did was they struck down and they removed and they deleted all the strictures and directions passed by this particular trial court judge, and they indeed made certain remarks against the trial court judge himself. So you understand the situation that first the trial court judge passes remarks strictures against the police officer. Police officer approaches the high court. High court then removes the strictures against the police officer and indeed in turn passes strictures against the trial court judge. So that is when he got in touch with me and he told me that, oh, such and such thing has happened, etc., etc. So I was pretty clear in my mind that firstly the kind of litigation that it would involve, it would definitely require a senior counsel to put his case forward before the High Court or the Supreme Court. So I took a call that initially, since remarks which were made against the trial court judge were passed without hearing him or without issuing him any notice or without calling for any comments from him on the administrative side. So I had suggested, and how we had strategized was that we would first go before the same High Court judge and seek a recall of that order, requesting that it may have been an oversight, it may have happened out of out of certain facts which may not have been brought to the High Court's knowledge, and that's what we filed a recall application before the High Court judge concerned. So we had briefed a decent senior counsel in that matter. I wouldn't take the name, But for some reason, the client felt that that particular senior counsel didn't deliver uh, enough or didn't press the matter enough. And however, I thought that it was perfectly fine. But the judge, the trial court judge, who was the client in this case, did think that it could have been placed before the High Court better. And he remotely suggested that because the respondents or the people on the other side were quite mighty influential, that is the CP Delhi, Union Home Secretary, Ministry of Home Affairs, that could have been the reason why, or something of that sort. That was what he had suggested. But be that as it may, we lost in the High Court, and then we had to file an SLP before the Supreme Court. And that is why and now I would like to give credit to, and because since that particular matter, I have appeared for some 10, 12 judicial officers, out of whom some 5, 6 belong to Delhi, rest belong to other states. But the actual credit in this first matter of this trial court judge, I would like to give the credit to Mr. Chidambaram, Mr. P. Chidambaram, because I requested him that whether he could appear in this matter for the trial court judge before the Supreme Court. And he graciously agreed, but not after a lot of convincing, which I had to do because we went to him. So on the first time, on the first day when we went to brief him about the matter, he was not that very convinced that whether we have a good case or not in the matter. And so he called me again that, okay, Sagar, come tomorrow again. So the next day when I went and I tried to impress upon him the impact which it would have. Because see, one thing which I just forgot to tell you, there was a rule of the High Court itself, a Delhi High Court rule, and the whole trial court judiciary or district court judiciary across Delhi is bound by that particular rule of the Delhi High Court, which said that no trial court judge, unless there are very strong reasons, can pass any remark, stricture, or direction against a police officer with respect to conduct or discharge of the police officer's functions, public functions. So there was actually a Delhi High Court rule which said that. And therefore, and that's very strange because these rules are quite old. These rules are like pre-independence, some are post-independence, immediately post-independence. So that's why in those times police was protected in all the manner, because police used to do a lot of excesses with the people during the British times. So these rules were there, and somehow it got overlooked and these rules were not deleted. But be that as it may, that rule was there on the rule book on that particular date. And that was the reason why every court was holding against the trial court judge that there is a Delhi High Court rule, you could not have passed strictures or remarks against the police officer. So be that as it may, so I did try to impress upon Mr. Chidambaram that this this also has a wider ramification, because this rule will also be challenged in this particular litigation, and therefore we would need him in that particular matter. And in that sense, it was not an individual matter only; it would have a wider ramification across the district judiciary. And so he graciously agreed, and I must say, of course, pro bono, he didn't charge anything from the judge concerned. He got notice issued in that matter. Again, I was fortunate enough that subsequently I uh, argued the matter on every date, and finally, when the matter was finally argued, I got an opportunity to finally also argue that particular matter and got the appeals allowed in favor of the trial court judge. And more importantly, that particular rule of the Delhi High Court was withdrawn by the High Court itself, because the Supreme Court, in one of the hearings, made it clear to the ASG concerned who was appearing for the Delhi High Court that if you do not withdraw this rule yourself, we would strike it down. So naturally, the High Court, in all magnanimity of that particular Chief Justice or whichever committee which was to take the decision, that in all magnanimity, they, instead of tweaking that rule in some different language or changing that rule in a particular manner, the High Court and the full court of all the judges of the High Court did take a decision that the rule had to be withdrawn and had to be removed from the rule book. So, to their credit, the High Court also took that call that they removed or withdrew that particular rule from the rule book. So that is the story of that particular matter. But since then, I've been doing a lot of those matters, and I must tell you that three additional Solicitor Generals, Mr. S.V. Raju, Ms. Aishwarya Bhati, and Mr. Brijinder Chahar, were appearing against me in that matter during the final hearing stage. So yeah, in that sense, it was a very challenging matter. And when the appeals got allowed, not just the client or that particular trial court judge in that sense, even I was quite happy, and I felt a sense of personal accomplishment in that particular matter. But since then, a lot of judges have come to my office, and they have they come to me. But in my mind, and I have always told that the real credit for succeeding in this particular litigation would be of Mr. Chidambaram, and I was only assisting him in a very in a capacity wherein of a briefing counsel, or say in a very assisting capacity to Mr. Chidambaram. But he led us in that matter, and he made sure that notice was issued in the matter, and Supreme Court did have a good look, a closer look at the matter. So